We'll give it just a minute here as people roll in. All right, welcome everyone to our class today on the Oregon Realtors Promissory Note and Deed of Trust. I'm Jeremy Rogers. I am the Director of Legal Affairs here at Oregon Realtors and one of the attorneys on the team. I've been involved in the development of our forms since that effort was launched. That process included our staff attorney, Nicholas Peasley, as well as a team of principal brokers from around the state that contributed greatly to the development of our forms. This is our latest installment in our weekly training on forms. It happens every Friday at 10. And we have a lot to get through today. And so I'm probably going to hold answering questions until the end to make sure we at least get through the content. I also want everyone to know that at 11 o'clock, we have our weekly open house, which I'll also be staffing. So I'll need to move over to that. That's an opportunity for folks to ask questions. So if you do have any lingering questions from this presentation, you're welcome to join in to that to ask those questions. So let's get started. So today what we want to cover, we want a quick overview of our training resources so that you know what else is available to you in addition to this class that you're taking today. We want to talk about seller carried transactions generally, a little bit about Oregon trust deed law, risk management for seller carried transactions. Then we'll talk about how to conduct seller carried transactions on Oregon Realtors forms. And then in particular, we will go through our promissory note and deed of trust document. So let's first talk about some training resources that are available to you through the website, which is orforms.org. Please bookmark that, keep it handy, lots of good stuff there. There is a training tab that you see highlighted here at the top of that website. If you click on that, you're going to see the options that are available to you. Right now, we are doing one of the live trainings and webinars. If you click on that button, it will take you to a list of all of the upcoming live trainings and webinars. That includes each of our Friday at 10 a.m. classes, but also there are sort of scattered throughout other classes as well, including our Using Oregon Realtors Forms class, which is sort of our baseline level training that teaches you how to use the residential sale agreement as well as some of the common addenda based upon some transaction scenarios that you are likely to face in your business. And that class is taught by principal brokers instead of the staff attorneys. We have self-paced trainings. These are trainings that you can take at your own time. I should mention that the live trainings are no cost. The self-paced trainings, there is a $15 cost to help with the processing of the CE. We partner with Online Ed on that, making those available to you via recording for CE credit. All of our live trainings that we do, we put into that self-paced training library when we are done. So there's a little bit of a lag for that to happen, but if you missed one of the live trainings, you can always watch it for CE credit through the self-paced trainings. Mention the virtual open house that occurs at 11 o'clock on Fridays. Either myself or Nicholas Peasley, our staff attorney, will be on there, and we essentially are available to you for you to ask any questions that you have about our forms. Okay, that's the whole point. We want you to know that every week you have an opportunity to talk to the attorneys that drafted the forms and ask any questions that you have. We are here for you to help you, whether you're transitioning to these forms or whether you have been using them for a while and are, facing new situations where questions may arise. We also have recorded tutorials. These are shorter form videos. They're not generally long enough for CE credit, but they provide important information. We've got stuff on there on navigating our repairs using our forms. We've got dealing with lead-based paint hazards using our forms. We've got information about how to navigate the environment with multiple forms libraries and getting some tips from some principal brokers about how they're managing that issue within their brokerage. So lots of good stuff on there. Generally, those are going to be more like 15 to 40-minute videos. We also have our guided forms library. So this is a great tool for you. It's sort of an evergreen tool. You can always go to it and it'll be just in time and relevant for you. All of our forms, we have created a version of those forms with video annotations. So if you pull up a form in our guided forms library, which you'll find if you scroll down the training page on our website, then you click on the green button that says guided forms with videos, and you will see little play button icons next to each section of each form. And if you click the play button, a video will pop up that has Nicholas explaining that section of the form. We've done that for all of our forms. We have hundreds of hours of video, hundreds of videos, because it literally is every single section of every single form. So there may be a couple of forms that we still don't have loaded up yet, but I think we're pretty close to having them all available. All right, so let's just talk about seller carried transactions generally, okay? What is a seller carried transaction? Well, the buyer wants to purchase an ownership interest in the property. Purchase must be financed because buyer does not have enough money to pay cash outright. Seller is going to take on the role as the lender. Property is going to be used as collateral to secure the loan. The seller is going to maintain or carry back a security interest for some or all of the purchase price. And there are generally two common approaches to this. One is the promissory note deed of trust. That's what we're going to be talking about more today. Also land sale contracts. So what is promissory note and deed of trust? Well, seller is going to lend to the buyer the money needed to purchase the property. At closing, the buyer is going to take ownership interest in the property. Okay, so there will be a deed made out in the name of the buyer. So that's going to be different than with a land sale contract, where the seller is going to maintain the legal ownership until the buyer has fulfilled all the obligations under the contract and it's paid off. The buyer is going to put up the property as collateral for the loan. The promissory note is going to lay out the terms of the repayment of the loan. The deed of trust, also called a trust deed, is going to secure the repayment of that loan and lay out the remedies for buyer's default under that loan. And the deed of trust is authorizing a third-party trustee to hold the title to the property in trust while the obligations are still being met under the loan, and the power to sell the property in the event of foreclosure. And then, of course, also the requirement to reconvey in its entirety the property to the buyer once the obligations under the loan are completely fulfilled. So this is how that is stated in the Oregon statutes. Trust deeds are creatures of statute. Okay, the Oregon Trust Deed Act was passed, I think, sometime in the 50s. The whole idea was that this was a way to sort of expedite, simplify, and create a more fair process to deal with residential property loans and foreclosures. Trust deed under the statute means a deed executed in conformity with these statutes, okay, which are listed there, which is the Oregon Trust Deed Act, that conveys an interest in the real property to a trustee in trust to secure the performance of an obligation that the grantor or other person named in the deed owes to a beneficiary. Okay, we'll talk more about who is who here. The grantor is the buyer, the beneficiary is the seller, and the trustee is the trustee. So who can be a trustee? Who can be this third party that's sort of going to hold on to this title and that is going to execute a sale, a non-judicial foreclosure sale if there is default, and who is going to reconvey all of that title back to the buyer in the event of the buyer performing the loan. It can be an attorney or a law firm that includes a member of the Oregon Bar, the financial institution or trust company that's registered to do business in Oregon, a title insurance company or subsidiary that's registered to do business in Oregon, the United States or an agency of the United States, or an escrow agent that is licensed in Oregon. That last one is often what is going to be used here, the title and escrow company acting as the trustee. And just to note, you know, we're talking about this in the context of our documents, but this is how the loan is going to work for your buyer, even if it's not a seller carried loan. Okay, when your buyer takes out what we all call a mortgage in Oregon, generally they're really doing the promissory note and the deed of trust, okay, even if we're working with a lender. What's the difference between a mortgage and a deed of trust? Well, they're similar, and in fact, you wouldn't be wrong to use the terms interchangeably, because Oregon statute says that a trust deed is deemed to be a mortgage on real property and is subject to all laws relating to mortgages, on real property, except to the extent that such laws are inconsistent with the Oregon Trust Deed Act. And if they are inconsistent with the Oregon Trust Deed Act, the Oregon Trust Deed Act will control. For the purposes of applying the mortgage laws, the grantor is in a trust deed is deemed to be the mortgager, and the beneficiary is deemed to be the mortgagee. But there are really some differences. Okay, now a mortgage is a common law concept. It's existed for generations. Trust deeds are creatures of statute, and I mentioned Oregon passed its Trust Deed Act in the 1950s. Mortgages only involve two parties. There's the lender and the borrower. Okay, the trustees involve the third-party trustee who holds legal title to the property in trust and then reconveys it to the buyer once buyer's paid off the debt, or administers the remedies, including the foreclosure sale if the buyer defaults under the loan. The remedies are different. Okay, under mortgages, it's generally going to be judicial foreclosure. Okay, the lender files a claim in court and goes through that process, the court process, to foreclose. The whole concept of why the Trust Deed Act exists is to create a non-judicial foreclosure process that's more simplified, straightforward, and clearly lays out the rights of all the parties. Okay, so that is what's in the deed of trust. Now, typically, the deed of trust is going to authorize either that non-judicial foreclosure process, or at the option of the seller, or what we're calling now the beneficiary, judicial foreclosure. So the seller is generally going to have an option of which to pursue. And then with a mortgage, the lender can accelerate the loan on default. With the trust deed, if the non-judicial foreclosure remedy is being pursued, the borrower has a right to cure the delinquency, just the delinquent portion, plus paying all costs and fees of the trustee and of attorneys involved in collecting, until 5 days before the trustee's sale. Okay, so that is a difference. If the non-judicial foreclosure process is going to be pursued, there will not be an acceleration of the debt. All right, let's talk more about the remedies here. So this is what it says in the Oregon statute we are quoting here. Where any transfer and trust of an interest in real property is made pursuant to provisions of the Oregon Trust Deed Act to secure the performance of the obligation, a power of sale is conferred upon the trustee. So that's the key term that's used here, a power of sale. Power of sale may be exercised after a breach of an obligation for which the transfer is the security, and a trust deed executed in conformity with the Trust Deed Act may be foreclosed by advertisement and sale. That's the phrase that's used to describe a non-judicial foreclosure, advertisement and sale, in the manner provided in this Oregon Trust Deed Act, or at the option of the beneficiary, which is the seller, may be foreclosed by the beneficiary as provided by law for the foreclosure of mortgages on real property. So like I mentioned, seller's going to have option here in terms of using the non-judicial or the judicial foreclosure process. So reconveyance, this is a key duty of the trustee. Within 30 days after the performance of the obligation that's secured by the trust deed, okay, that means that the buyer has paid the loan off, the beneficiary shall deliver a written request to the trustee to reconvey the estate of real property described in the trustee to the grantor. Okay, within 30 days after the beneficiary delivering that written request, the trustee shall reconvey the estate of real property described in the trust deed to the grantor. Again, grantor is the buyer, beneficiary is the seller. All right, but the whole idea here was to set up a process in statute that was fair and that more clearly lays out the rights and responsibilities of all parties. So there are steps that are involved when you when there is a foreclosure on a trust deed. There must be a resolution conference to try to resolve these issues to avoid the foreclosure, or an affidavit from the beneficiary that they have not foreclosed on more than 30 residential properties in the previous year. So folks you're working with probably going to be in that category of the affidavit. But this resolution conference, the idea is that if you're dealing with banks or lenders and they're doing a lot of these foreclosures, they don't, we don't want foreclosure mills in Oregon. We want these banks to be working with the borrowers trying to figure out how to resolve this without foreclosure. Certificate of compliance, which is going to demonstrate that you either did do that resolution conference or that you did provide that affidavit. There has to be at least some evidence that the buyer is, or again, the grantor, okay, is ineligible for certain foreclosure avoidance measures. Okay, there are a series of foreclosure avoidance measures. Again, state law prefers that those be pursued, but if buyer slash grantor is ineligible for those, then the procedure can go forward. Foreclosing by advertisement and sale, again, that's what we call our non-judicial foreclosure. In order for that to happen, the trust deed must be recorded in the county where the property is located. The grantor must be in default under the terms of the trust deed and the promissory note. The trustee or beneficiary must have recorded a notice of default containing numerous statutory requirements. We're not going to go into what all those are. They are lengthy. There also must be notice to the grantor, okay, slash the buyer, that the notice of default was issued and recorded, and at least 120 days before the trustee conducts the sale, the notice of sale, there must be a notice of sale to the grantor and any of the grantor's successors and interests, any person that has a lien or interest subsequent to the trust deed, and any person that requests notice. Okay, so there's a lot of boxes that must be checked before the foreclosure can go forward. What's in that notice of sale? The notice of sale is going to do a lot of things. Okay, I don't think I'll read these all. You can see them here. It's going to have a lot of information, but the one that I want to draw your attention to is number 8. Okay, and this is in the notice of sale, but what I really want to talk about here is what this is, because this is sort of a key function of the Trust Deed Act and why trust deeds are used. So the notice must state that grantor's right exists to have this whole proceeding for foreclosure dismissed and the trust deed reinstated by the buyer slash grantor paying the entire amount due, together with the costs, trustees and attorneys' fees, and by curing any other default that was identified in the notice of default. And they can do that at any time, not later than 5 days before the date of the sale. Okay, so this is sort of the key protections for the buyer slash grantor using the trust deed. Okay, they can pay that off, just the deficiency plus costs and trustees' costs and attorneys' fees, up until 5 days before the sale, and then that trust deed is reinstated and they're back in business, and everything's back on track. Interestingly, they also have to provide in the notice of sale a statutory notice about that the property could have been used to manufacture methamphetamines, and then a notice to tenants if there are tenants in the property. And I know a lot of folks are interested in landlord-tenant law, so I just wanted to let you know a little bit of detail about that. When you're dealing with a non-judicial foreclosure under the Trust Deed Act, sort of what are the rights of tenants if the property is tenant occupied? Well, the tenants can stay through the foreclosure sale, and then the buyer is going to have to notify the tenant, the buyer at the foreclosure sale. Okay, this new owner that purchased it at auction is going to have to notify the tenants that they're the new owner and of their rights. And there are special timelines for the termination. So that new owner that bought it at foreclosure sale can terminate a tenancy of an existing tenant with 60 days notice if the tenancy is a fixed term lease, or 30 days notice from the date if it's a month-to-month lease. Okay, so these are shorter timelines than would otherwise be allowed at law. And in fact, here, this new owner of the property can even terminate the lease, even if it was still going on, with 60 days notice. If the new owner is a primary resident of this property, the new owner can give 30 days notice, even if there is a fixed term lease. So then the property would be, let's talk about the trustee's sale. Okay, if a property is foreclosed under a deed of trust, there are some rules about the trustee's sale. It has to happen on the date, time, and place that was designated in the notice of sale that we talked about earlier. It has to happen between 9 and 4 p.m. It has to be in the county where the property is situated. Trustee may sell the property in one parcel or separate it into multiple parcels, okay, and auction all of those separately or together to the highest bidder for cash. Any person, including the beneficiary and the trustee, but excluding the trustee, may bid at the trustee's sale, and the purchaser shall pay at the time of the sale the price that they bid within 10 days, and within 10 days following payment, the trustee shall execute and deliver the trustee's deed to the purchaser. So that is how that sale process happens. If there is a foreclosure under the Trustee Act, then this is the order of proceeds of that sale. So if the sale goes forward, how are the proceeds applied? First, to the expenses of the sale, including compensation of the trustee, reasonable charges from any attorneys that were involved. Second, to pay off the obligation that was secured by the trustee. Okay, so to pay off the grantor's loan. To all persons having recorded liens subsequent to the interest of the trustee and the trustee in the order of their priority. And then if there's any surplus, back to the grantor of the trustee. Okay, so if there was a surplus, even though that buyer went through foreclosure, lost the property, they would get any excess proceeds. That grantor would get the excess proceeds back to them. Now there are some special rules specifically for residential trust deeds. A residential trust deed is a trust deed that is securing a promissory note on 4 or fewer residential units, one of which the grantor or the grantor's spouse or grantor's minor or dependent child occupies as a principal residence. If that's the case, then in an action, there may not be an action for a deficiency judgment brought after the trustee's sale. Okay, so if the sale proceeds from the auction are below what that grantor owes, they can not be held responsible to pay the difference if it's a residential trust deed. Okay, and that's even true if you're using a trust deed, even if the beneficiary opts for the judicial foreclosure route instead of the non-judicial foreclosure route, the grantor will not be liable for any deficiency if a trust deed was used that complies with this act. There's also a limitation on the amount of attorney's fees and trustees' fees that a grantor would be required to pay, because the statute says and our contract says that the grantor is the one that has to pay those fees, but the statute limits that to $1,000. Okay, so even if those costs were higher than $1,000, it's limited to $1,000 if it's a residential trustee. These protections that I just talked about here do not apply if it's not a residential trustee. Okay, so if it's a commercial property, these protections for the buyer do not apply. Now, let's just briefly talk about land sale contract, an alternative method of conducting a seller carried transaction rather than using the promissory note and deed of trust. These are used less frequently these days. I think really the preferred method by most is to use the promissory note and deed of trust, because you have a lot of clear direction laid out in statute. Everyone knows what their rights are, and there's an efficient process to deal with foreclosures. So in a land sale contract, though, a seller is going to convey to buyer the right to purchase the property under the terms of the contract, okay, under the term of this land sale contract. The buyer is going to take possession of the property, but the seller is going to retain title until buyer has performed their obligations under the land sale contract. So this is different than when you're using promissory note and trust deed, where the title that actually transfers to buyer, and then buyer gives that to a third-party trustee to hold for a period of time until the buyer's paid off the loan. Here, the seller is going to retain title until the buyer's fulfilled all their obligations. And here there is only 2 parties involved. There's the seller and the buyer. There is no third-party trustee. Upon fulfillment of buyer's obligation, the seller is going to transfer title to the buyer. They're going to use a fulfillment deed to do that. Rent to own is kind of a common way that this is done or thought about. Okay, buyer is living there. Buyer is paying monthly payments. They have a right to purchase the property, and those monthly payments are going to pay down that purchase. And then ultimately they will pay it off. And there may be some terms in that land sale contract that provide a period of time where that payoff needs to happen by. These rules are defined by the contract rather than the statute. Okay, so sometimes sellers like the land sale contract because they get to define the rules. If buyer agrees, of course, it's a negotiation, so both parties can influence that negotiation. But generally speaking, the sellers are more land sale contracts are going to be more favorable to the seller because they're going to provide more options for remedies. It's really kind of limitless. The remedies that y'all put in the contract are going to be the ones that are available. And you don't have to follow all of these procedures under the Trust Deed Act. So, but again, there are a lot of benefits, I think, not only to the buyer, but also the seller of using a trust deed and having those procedures laid out so clearly, and having sort of a balance of protections for each party as is provided in the Trust Deed Act. So I really do think that is a good way to go. And we'll talk about this later. However, your role as a real estate agent is not to advise your client on which way to do their seller carried transaction, not on which legal instrument to use, also not on the details of the financial terms of that. So we'll talk more about that here in a bit. So doing seller carried transactions on Oregon Realtors forms, let me sort of start high level, and then we'll drill down into our promissory note and deed of trust document. So you probably have all seen this. This is our document 0. It's the table of contents for our forms library. The first step in doing a seller carried transaction with our forms is to use the appropriate sale agreement for the type of property that that the buyer is going to be purchasing. Okay, so whether it's residential, commercial, manufactured home, agricultural land, or vacant land, you want to start with the right sale agreement. You're going to need the sale agreement in addition to the other documents that you're going to be using. So that's step 1. Step 2 is using the appropriate seller carried documents. We're going to walk through these. In every instance, you're going to use 8.1. That's our seller carried addendum. But then we also have the promissory note and deed of trust. We also have a land sale contract and a memorandum of land sale contract, which is what would be recorded if you use the land sale contract. We also have our advisories that should always be given to the buyer and the seller, and they include advisories related to seller carried transactions, 10.1, 10.2. So you pick the sale agreement that's appropriate for the property. We'll take a look at this here in a second, but in that sale agreement, there's going to be a section that asks about conveyance, and it's going to have an option for seller carried transaction. So you want to check the appropriate box on that conveyance section in the sale agreement, okay? And again, that choice of whether you're going to use a promissory note deed of trust or your client's going to use, or the land sale contract, there's a box for that on the sale agreement, but that choice should be made by the clients with their own legal and financial advice, not from advice from you, okay? The clients are going to complete the form 8.1 seller carried addendum. If you're filling that out for them, you're acting as a scrivener only, okay? You are not advising or coaching them about the legal or financial aspects of that transaction. Then you're going to work with a title and escrow company. So, and this is where it kind of oddly, I'm going to tell you, don't use we're going to talk today about our promissory note and deed of trust, but I'm going to tell you, don't use it because you don't need to use it. We have it there as sort of a backup last resort, but your client's going to be working with the title and escrow company anyways to close this transaction and to handle any earnest money and other monies. That title and escrow company can take our form 8.1 seller carried addendum, which at a high level lays out the details of what the parties want in the seller carried documents, and they can be the ones that act as the scrivener to write up a promissory note and deed of trust using their own forms, and then act as the trustee. Okay, that is a far preferred way of doing this. We have documents available in case your client maybe is in a community where there isn't a title and escrow company that will do that, but always check there first. That's the way to go, okay? Last resort, all right? Ours are there as a last resort. And this is just more, clearly when I put this presentation together, I wanted to emphasize this point because I got another slide on it. Yeah, you shouldn't need to use our promissory note and deed of trust. Escrow companies are gonna have those. And what they're going to want to see is that form 8.1 that has all those details, because they're in the same position. They only want to act as a scrivener. They don't want to be advising the clients about the details. So they want the client to come to them with the details, and then they'll produce those documents. So yeah, the purchase and sale agreement in the form 8.1, that would be what that title and escrow company would need to then take it from there. Risk management for seller carried transactions. As I mentioned, you're only a scrivener, okay? You're not giving your client any advice, or the other party, anybody, advice regarding the best method. Hey, here's why you should do a land sale contract. Here's why you should use promissory note deed of trust. That's the legal issue. They should talk to their own attorneys about that. Do not give advice regarding the financial terms of seller carry transactions. Now, you can point your client to places, if they're trying to find, just, hey, where do I go to find typical interest rates? And you've got a good link, where they can go, or some resources there, or amortization tables or things like that. Okay, but don't advise them about the details of their choices on the financial end. Do instruct your client in writing to involve legal and financial experts in advising them. And be aware that there are laws. These are described in our seller carry addendum. There are laws where a mortgage loan originator would be required to be involved in the transaction. A person who is licensed by the state of Oregon to deal in originating mortgage loans. We'll talk about that here more in a minute. So let's go through the steps together. Oregon Residential Purchase and Sale Agreement. So we're assuming we're doing a residential transaction here. Here is our residential sale agreement. On that first page, there is section 6, conveyance. It asks, will the transaction be accomplished by way of deed, or if this transaction is seller carried, it tells you 1, to use our form 8.1 seller carried addendum, and 2, check the box about whether a promissory note and deed of trust will be used or a land sale contract will be used. There is an Oregon regulation that says every offer to purchase real property in Oregon must state whether the transaction will occur by way of deed or a land sale contract. Okay, so we're complying with that here. We're putting it up front because this is sort of a key decision that needs to be made and a material term of the transaction. So again, your client's going to be the one making that decision, but it needs to be communicated here in the form. Then you're going to use the seller carried addendum. So we'll walk through the seller carried addendum first, then we'll move on to the promissory note and deed of trust, because as I said, the document you primarily are going to need is this seller carried addendum, and then you're only going to actually need to use the promissory note and deed of trust if your clients, for some reason, don't have another option for accomplishing that. So here is the seller carried addendum. Okay, this is where the parties are going to memorialize the details that they want to include in the ultimate seller carried instrument. Okay, that they want to include in the promissory note and the deed of trust. The seller carried loan amount. Okay, so this is the amount that the seller is financing. The interest rate. You might ask, well, why don't we give more options on interest rate? We do have an other. Okay, so you can specify other. One of our goals with creating these documents was to try to keep things simple. Okay, and to try to protect people from doing things that could otherwise be a violation of law. We don't want people to charge absurd interest rates because they could be in violation of different usury laws related to acceptable interest rates. We don't want people to charge too low of an interest rate because then they may be giving a gift to the other party, and that brings in a whole series of tax implications and the need to file gift tax returns and things like this. So we're laying out sort of what we think are a reasonable range of interest rates. We do have the other category though, so that there is an ability to put other options. Same thing with the terms. Okay, I know a lot of people like to do a lot of interesting things with terms. We've laid out a set of terms: 1, 2, 3, 5, 10, 15, 20, 25, or 30 years. So again, trying to keep those options sort of cabined in a reasonable range of options. Date of first payment. Okay, whether or not there's a due on sale clause. Okay, meaning if the buyer here ends up selling or transferring the property without the seller's consent, then the full amount would be due on that sale. Okay, that is likely something that the seller is going to want to include here. It's pretty typical, but we have that as an option. The parties can choose whether they want to amortize the financing. There's a checkbox option for that. And what we say here is that they will agree on that amortization schedule prior to mutual acceptance of the actual documents of the actual, like in this case, we're talking about promissory note and deed of trust, or if it was a land sale contract in that case. So we don't lay out the amortization table here. But it's an option if they want to amortize, and then the parties are going to go and have to select what that schedule is and agree on that. There's an option to include a balloon payment. If the parties do want to include a balloon payment, then they must consult the licensed mortgage loan originator, the MLO. Okay, we talked about that earlier. So they'll need to keep that in mind. And again, we're trying to protect everyone's interest and keep everyone in compliance with both state and federal laws. They can set a schedule for payments, okay, monthly, every 6 months, yearly. And then they can designate who is the party that will be collecting those payments. There can be an option, select an option for a prepayment penalty, whether the buyer may or may not prepay, okay? And if the buyer prepays, whether or not there is a prepayment penalty and how much that prepayment penalty is. If there is a prepayment penalty, we say that you cannot use our seller carried documents. Okay, so you can't use our land sale contract, you can't use our promissory note and deed of trust. We don't like prepayment penalties, and we haven't even put a place for that on our promissory note and on our land sale contract. Late fees. What are the details of the late fees? Okay, 5% option, or put in option to pick a particular number for the late fee. Okay, the next section here, oh, sorry, the Scrivener's Agreement. This is key risk management for you, making it clear that the agents, both buyers and sellers agents, are merely scriveners in helping to complete this document. Okay. I mean, my preference would be that the clients themselves are filling out this document, but I know the way that the forms work and how you fill them out tends to be you that are filling them out as the agent, but it needs to be clear that you're only doing that at their direction as a scrivener, and you are not advising them on the details that they're choosing here. In the next section, this is where the parties are going to indicate which documents they're going to use to effectuate their seller carried transaction, and sort of whose documents they're going to use. Okay, so they can work with an attorney to do a promissory note and deed of trust. Then they're going to specify the name of the attorney. They can work with an attorney to do a land sale contract, specify the attorney. They can use the escrow provided promissory note and deed of trust, then specify which escrow. As I mentioned, that I think is a very common option and probably a pretty good option for most folks. Or if they're going to use our forms, they're going to select which forms they're using, either our promissory note and deed of trust, or our land sale contract and memorandum of land sale contract. We then have other format options. So if there's an option here that's not listed, the parties can use that. Okay, but really, I would say working with escrow, probably the most efficient, obvious option. Working with attorneys, still better, much better than just using our forms, but our forms are there if needed. And maybe the attorneys actually like our forms and want to use our forms, but they're still working with an attorney to do it. Here are the rules for mortgage loan originator. And I won't go in too much detail because I know that we only have an hour, and we still haven't gotten to the promissory note and deed of trust. But these lay out the mortgage loan originator rules. These are also included in our seller advisory. And if any of these things are true that are listed here on the slide, then the parties need to consult with a licensed mortgage loan originator. Okay. That includes the sellers entered into 3 or other seller carried transactions to purchase residential dwellings in the last year. Okay. If the seller's doing this as a business, then they need to consult with the mortgage loan originator. Okay. Not using a mortgage loan originator is designed just when, this is sort of a one-off thing for, people's own residential property that they're living in. Is not when people are doing this as a matter of course in a business. If that's the case, you need to use the mortgage loan originator. Sellers entered into more than one other seller carried transaction with a high cost mortgage in the last year. That term is defined in our seller advisory. I also have it on the next slide. We can take a look at what that means. If the seller has entered into one or more other seller carried transactions where they already have used an MLO, they'll need to use an MLO again. If the seller has 8 other seller carried residential mortgage loans at any given time, okay, or 12 seller carried mortgage loans on manufactured homes. Okay, again, if that's the case, sellers kind of running a business out of this here. If the parties intend for the promissory note or land sale contract to have a balloon payment or adjustable rate, then they need to use a mortgage loan originator, or if the seller does not believe in good faith that the buyer can actually repay the loan. Okay, so we're just here trying to protect the parties, make sure they're complying with the state and federal laws that outline when these mortgage loan originators are required. The high cost mortgage issue, what does that mean? High cost mortgage, typically defined in the Truth in Lending Act as a first mortgage at more than 6.5% above the average prime offer rate. The average prime offer rate is available online and it's updated weekly. In our seller advisory, we have links to these places. Okay, we have links to the average prime offer rate, so folks can see what that is and do a calculation. If the seller is trying to establish a subordinate or junior mortgage or establishing a mortgage on a manufactured dwelling or household that costs less than $50,000, different rules are going to apply. In that case, sellers should seek out an MLO to help assist them in understanding what they need to do. There are some exceptions to the MLO requirement. If the seller is operating or negotiating terms of a residential mortgage with or on behalf of the seller's spouse, child, sibling, parent, grandparent, or grandchild, the seller's operating or negotiating terms of a residential mortgage loan secured by a dwelling that served as the seller's residence, or if the seller has an Oregon licensed attorney that is negotiating the terms of the mortgage and the attorney does not receive compensation from a mortgage banker, broker, or loan originator. So those are some exceptions to the requirement for MLO. We could do a whole class on the whole MLO thing. Maybe we will do that. The next section in our seller carried transaction, our seller carried transaction addendum, is the creditworthiness section. This is where the buyer is going to demonstrate their creditworthiness for entering into this loan with the seller, and the seller is going to have a period of time to review those documents and to terminate the transaction if they believe the buyer is not creditworthy. So here the parties are going to pick a time frame. They're going to pick what sort of written evidence is going to be used to validate the buyer's creditworthiness. Excuse me. So they can check as many of these as they want: credit report, verification of employment, verification of funds, current financial statement, other. Seller's going to have 5 business days to review the documents that are selected, and they can terminate by using our seller's notice of termination if they do not believe that the buyer is creditworthy. Excuse me. All right, the next section here is going to deal with tax and assessments. So unless that ultimate promissory note and deed of trust state otherwise, okay, buyer is going to be responsible for payment of all property taxes, association dues, special assessments, and buyer required insurance premiums. Buyer is going to pay these based on the options that are selected here: directly to seller monthly, directly to an escrow agent, specifying which escrow agent, or directly to the party that is going to ultimately receive those funds, the county treasurer, association, or insurance company, depending on what type of payment it is. This drafting deadline that we have in here saying, hey, because this is the addendum that's laying out the terms, the parties still need to go and actually complete that promissory note, deed of trust, or the land sale contract if that's the direction they're going. So here we're putting a deadline. If the seller carried transaction documents are not attached to the sale agreement, like they're not done at the time of completing this document and the sale agreement, then the party drafting those documents must deliver the completed documents within a period of time. And so the parties can check here 10 business days or some other number of business days. And in no instance can they be delivered less than 5 business days before closing. Unless if escrow is drafting the documents, it can be within 3 business days before closing. Why is that? It's because escrow needs those documents, and they have to provide certain disclosures to the parties within 3 business days before closing. And so the documents need to be done in time to get those to escrow if it's not escrow drafting them, so that they can do the appropriate disclosures, or if it is escrow drafting them, then they'll already be positioned to do those disclosures with the 3 business day timeline. We heard a lot from the escrow companies that when people are not using the escrow company to draft the promissory note and deed of trust, that they are receiving these documents too late, and it's delaying closing because they can't comply then with their obligations under state and federal law, giving at least 3 days for those disclosures. We do have a statement here about controlling documents. If there's a conflict between what the parties put in this addendum and then what they put in their actual instruments that they're using, like the promissory note and deed of trust, then that promissory note and deed of trust is going to control over what was put in here, because it's going to express the final intent and be the actual agreement of the parties. So that is the seller carried addendum. Let me blaze through the promissory note and deed of trust. So again, shouldn't actually need to be using these documents because you can go to escrow, clients can go to an attorney, but they're here, so I want to explain them to you. The first section of our promissory note, you're going to identify who is the maker, that's the buyer, who is the holder, that is the seller. Name, address, and effective date. The next section is the promise to pay. Okay, so this is the kind of crux of the promise that is being exchanged here in this transaction. The buyer is going to individually, or if it's multiple, joint and severally, name themselves here, promise to pay to the holder, the seller, name that party, name the seller there, the amount, okay, with interest accruing on the principal. And you can put in the sale agreement number in the field there. And you're going to put the county. Okay, so pretty straightforward. The next section, these are the financial terms. Again, you already got a lot of this information from that seller carried addendum. Now we're just fleshing it out, transferring it on to the actual promissory note here. So here, you're going to select the term of the note. Okay. When does the entirety of the note need to be paid off? You can pick the 1, 2, 3, 5, 10, 15, 20, 25, 30. Okay, just like in the seller carried addendum. When is the first payment due? Okay. Will there be a balloon payment? Okay, so again, you're seeing a lot of just this. This is a lot of repeat because the whole point of filling out that seller carried addendum was to be able to sort of transfer stuff onto this document. Again, risk management, you are not qualified as a real estate agent to provide opinions on the validity or advantage of selecting different provisions within this note. They need, clients need to seek their own financial and legal advice. Do need the mortgage loan originator for the balloon payment. Interest rate will be selected here. Again, those are the same options that were on the seller carried transaction form. Now, on the seller carried transaction addendum, we had the other, okay? Because if the parties are going to someone other, using something other than our documents, other than our promissory note here, maybe whoever's drafting that is comfortable with a rate other than what's given here. We actually tried to cabin in the choices to protect all parties. So if you're using our documents, these are the only options here. On the actual promissory note, we don't have an other option. Okay, and then again, selecting the amortization option. Payment schedule, okay, frequency of payments, what the monthly and or regular installment amount is going to be, due dates, okay, consequences of failure to make payment. Okay. The next section on financial terms, application of payments, first applied to outstanding fees or charges due, second to any interest on the note, and third, any remaining sums to be applied to the principal on the note. Section G there, who is going to be receiving the payments. Okay, if there's a collection escrow, then filling out the details of the collection escrow. If it's other, then attach the other information. Will there be a late fee? Okay, if so, then we check the box here. We have for the late fee, 5% here. Again, we actually have fewer options in our promissory note than we give in the actual seller carried addendum. If folks want more options, they should use a different document than our document. Due on sale provision, prepayment terms. Now, one thing to note on due on sale, okay, there's an act, federal law, it's called the Garn-St. Germain Act. It says that a due on sale clause cannot be enforced in certain instances. Okay, and I highlighted a handful of these here because these are common things, particularly in estate planning for your clients. Okay, not that you're doing the estate planning, but a lot of your clients might independently be doing their estate planning. And so even if the note has a due on sale clause, if the sale or transfer is to a by devise or dissent or operation of law on the death of a joint tenant or tenant by the entirety, then there is not, that due on sale clause cannot be enforced. If it's a transfer to a relative resulting from the death of the borrower, it cannot be enforced. Transfer to a spouse or child during the owner's lifetime, or, and this is the most very commonly used thing if you're dealing with a revocable living trust. If the property is transferred into a revocable living trust, and the borrower is and remains a beneficiary of that trust, then the due on sale clause will not be triggered. Okay, the parties may still need to notify in this case would still notify the seller, but they wouldn't. The seller would not be able to enforce that due on sale clause. The next section here is default. What happens in the event of a default? And I won't spend a lot of time on that because I want to get to the deed of trust because we're going to talk about some of these issues there as well. The remedies on default. Okay, so here we're providing a series of remedies that the seller is going to be able to select if the buyer does default. So we provide several options on remedies: acceleration, foreclosure, either judicial or non-judicial, and any other remedy that's permitted under Oregon law. But again, if a non-judicial foreclosure is going to go forward, then acceleration is not an option because you cannot do acceleration with a non-judicial foreclosure. Other provisions, these are miscellaneous provisions of the document. We're out of time here soon, so I can't go through all of these. Make sure that you take time to review them. And then the parties are going to execute this. It needs to be notarized. Okay. All right. So now let's talk about the deed of trust. Deed of trust. This is going to be recorded. We have up here formatted this for recording. The fields here are required for the recording. So after recording, return to, that has to be on there. We're naming the parties: the buyer, the seller, the trustee. Should have put the slide earlier, but we talked about this. Beneficiary is the seller, grantor is the buyer, the trustee is the third party fiduciary. We start deed of trust. We have certain recitals here, okay, to fill in some basic information about the property and the promissory note that is associated with this deed of trust. Again, emphasizing here in C that both grantor and beneficiary acknowledge they've been advised and given an opportunity to seek independent legal counsel to review deed of trust. This next section, again, just laying out some of the key terms that were included in the note. Okay, the principal amount, the interest rate, when the balance is due and payable in full. The deed of trust then goes through a series of obligations, okay, that the grantor or the buyer has, including maintenance of the property, restoration of the property if there's any damage to the property, compliance with all state, federal, and local laws related to the property, requirement to maintain insurance, requirement to keep property free from any encumbrances and any liens, removal of any priority encumbrances and liens, payment of costs of the trustee if costs are incurred, and will be at least some costs, and securing the services of the trustee, even if it's an escrow company, and indemnification of both the beneficiary and the seller and the trustee if legal action results from actions by the grantor related to this trust deed. The grantor and the buyer and the beneficiary seller are going to make some mutual agreements and obligations. Buyer is going to maintain exclusive right to possession and enjoyment of the property during the term of this deed of trust. Excess, if there is an eminent domain proceeding or condemnation proceeding where the government pays to take over the property so they can use it for some public interest, any excess payment will be used to pay the debt on the note. Trustee permission, so this is the buyer is authorizing the trustee to do all the things that the trustee needs to do to be able to act as the trustee. Both parties are agreeing to put no further encumbrances on the property without the beneficiary's permission. We talk about collecting proceeds and the due on sale clause. Running out of time here, so I'm just trying to zip. We explain default under the deed of trust. Okay, it's for non-payment is a reason for default, incorrect or incomplete representations or warranties that the grantor provided in executing these documents. If the grantor fails to perform any term or covenant obligation that they have made in the promissory note or the trust deed, if the grantor files for bankruptcy or otherwise has a court get involved in appointing a receiver or a conservator or something like that, then that would be a default. Grantor experiences a change of control of ownership. So if it's an entity that's the grantor and there's a change in control of ownership of the entity. There must be a notice of default that where the beneficiary seller provides the grantor our form 5.2 notice of default and opportunity to cure, giving the grantor at least 5 business days to cure any default before pursuing remedies. Now, this is a different notice of default than the one we talked about that's required if the beneficiary here is going to pursue a non-judicial foreclosure. This is the notice of default that's part of our forms library, and that's going to give the buyer / grantor the opportunity to catch up on those payments before pursuing any further remedies. So it's a first step before we even get to those more severe remedies. Later on, if there is going to be a non-judicial foreclosure, there'll need to be a separate thing called a notice of default that is filed and recorded with the county recorder. Remedies, again, as we spelled out in the promissory note, the seller / beneficiary has options on remedies. But some of these remedies will foreclose other remedies. As we mentioned, acceleration will not be an option if non-judicial foreclosure is pursued. And really, one of the major reasons why you're using the deed of trust is the ability to pursue the non-judicial foreclosure. Okay. We do explain the priority of funds upon the sale. We already talked about this. This is actually laid out in statute, so we're just memorializing it here in the contract. And then we have additional provisions in the contract. Again, won't go through all of those here, but there are additional provisions that are important and similar to some of the ones that are in our other sale agreements and contracts. This must be notarized. Okay, this deed of trust, it must be recorded. Okay, so I think we're at 11 exactly. I need to hop over to our open house. I'm just going to pull up the Q&A really quick. Okay, since I have to hop over to this other one, I am taking a shot of these questions, and then I will get back to folks with answers to those questions. And folks are also welcome to hop over to the open house. And just quickly, Richard, there's no we talked about deficiency judgments. Okay, there can't be a deficiency judgment if in the if it's residential and we're using the trust deed. Right of redemption, there's no general right of redemption like that like there is in the judicial foreclosure. It's but there are some instances for a 10-day period after the sale where the grantor / buyer could actually get the property back. So it's a more limited right that's based upon whether there was, for example, agreements related to foreclosure avoidance remedies, or if there was a mistake or violation of law that was made by the trustee in conducting the sale and things like that. So it's very limited. All right, how do we fill out 8.1 prior to making the offer? So Richard, on that, how do you fill out prior to making the offer? The parties can fill that out prior to making the offer, or they could make the offer in the sale agreement and then fill out the details of the seller carried addendum. Okay, so you could do that either way. What you at least need for the sale agreement is to indicate what type of transaction they're going to do, promissory note, deed of trust, or a land sale contract. Preferably, they would work out those details and do it simultaneously with the sale agreement. Okay. Same question that Heidi mentioned there. Parties need to come to agreement prior to acceptance of an offer or prior to closing. Heidi, I'm not sure I understand that question, but it looks like you say never mind. So it looks like we answered it during the presentation. So, all right, I'm gonna hop over. Sorry, I had to zip through those, and we will see you at the open house if you want to do that. Thanks.